information from the Equal Opportunity Employment Commission, what you should know about COVID-19 and the ADA, the Rehabilitation Act, and other EEO laws. As with anything related to COVID, this information may change. For the most up-to-date information, please consult the EEOC website. Disability-related inquiries and medical exams. How much information may an employer request from an employee who calls in sick in order to protect the rest of its workforce during the COVID-19 pandemic? Answer: during a pandemic, ADA-covered employers may ask such employees if they are experiencing symptoms of the pandemic virus. For COVID-19, these include symptoms such as fever, chills, cough, shortness of breath, or sore throat. Employers must maintain all information about employee illness as confidential medical records in compliance with the ADA. When screening employees entering the workplace during this time, may an employer only ask employees about the COVID-19 symptoms EEOC has identified as examples, or may it ask about any symptoms identified by public health authorities as associated with COVID-19? Answer: as public health authorities and doctors learn more about COVID-19, they may expand the list of associated symptoms. Employers should rely on the CDC, other public health authorities, and reputable medical sources for guidance on emerging symptoms associated with the disease. These sources may guide employers when choosing questions to ask employees to determine whether they would pose a direct threat to health in the workplace. For example, additional symptoms beyond fever or cough may include new loss of smell or taste, as well as gastrointestinal problems such as nausea, diarrhea, and vomiting. When may an ADA-covered employer take the body temperature of employees during the COVID-19 pandemic? Generally, measuring an employee's body temperature is a medical examination. Because the CDC and state local health authorities have acknowledged community spread of COVID-19 and issued attendant precautions, employers may measure employees' body temperature. However, employers should be aware that some people with COVID-19 do not have a fever. Question: does the ADA allow employers to require employees to stay home if they have symptoms of COVID-19? Answer: yes. The CDC states that employees who become ill with symptoms of COVID-19 should leave the workplace. The ADA does not interfere with employers following this advice. Question: when employees return to work, does the ADA allow employers to require a doctor's note certifying fitness of duty? Yes. Such inquiries are permitted under the ADA either because they would not be disability related, or if the pandemic were truly severe, they would be justified under the ADA standards for disability-related inquiries of employees. As a practical matter, however, doctors and other healthcare professionals may be too busy during and immediately after a pandemic outbreak to provide fitness for duty documentation. Therefore, new approaches may be necessary, such as reliance on local clinics to provide a form, a stamp, or an email to certify that an individual does not have the pandemic virus. There are a total of 14 questions in Section A, Disability-Related Inquiries and Medical Exams, as it relates to COVID-19. Pause the video and take a look at the answers to the rest of the questions. As I stated before, with all information as it relates to COVID-19, check the EEOC and other government websites often. If you have any questions, please leave them in the comment section below. If you want to know more about business operations, business management, human resources, and other topics related to running a business, click on one of those play links. Click on the playlist.
One eternity later.
Click on one of these playlists. Thanks for watching. And don't forget to subscribe.